must represent, each subsequent bail application must represent a new change in circumstances. And as authority for that proposition, he has relied on the case of Opio Simon Peter versus Uganda, and also on the case of Kantanga versus Uganda, where an Indian case of Kalyan Chandra Sakur versus Rajesh Kumar. My learned friend has described the Opio Simon Peter decision as, in his words, a locus classicus. My Lord, we submit that the decision in Opio Simon Peter was actually a decision made per curiam. The overriding consideration in the bail application was determined by the Supreme Court of Uganda in the case of human rights, from the Foundation for Human Rights Initiative versus the Attorney General, which was Constitutional Appeal number 3 of 2009, where the right to make an application for bail, the court said that the accused person's right to apply for bail must remain preserved, and that even the TIA does not take away the right to make this application as guaranteed under Article 23, Clause 6. Insofar, therefore, my Lord, as the decision in Opio Simon Peter seeks to limit, my Lord, as authority for this, we rely on the Constitution, Article 132, Clause 4, which provides that a decision of the Supreme Court on the point of law is binding. The Supreme Court, my Lord, removed all things that fetter the discretion of a court to grant bail. In fact, even the exceptional circumstances are now only a guide. Lastly, on that point, my Lord, insofar as the court relied on an Indian decision, not only is that decision not binding on this court, we submit it shouldn't even be persuasive when there is binding authority. The stage at which this trial has reached have circumstances of the trial, and therefore there's a lot of time that would be required to go through 7 volumes of the proceedings, more than 20 exhibits, and my Lord, we've highlighted all of these. Votes are the same, and based on no evidence whatsoever, claim that Dr. Chisambu, Commissioner of Health Services in prison, is junior to the Mulago doctors. While it's actually not based on any evidence, and in fact it is probably untrue, but even were it to be true, it's the very ground on which the applicant should be released on bail. There are no senior doctors where she is. A few misconceptions that were given about Dr. Chisambu. He said Dr. Chisambu simply performed a review of the medical report. My Lord, an extra E1, which is Dr. Chisambu's report, paragraph 2, and I beg the indulgence of court if I can it's just a very short sentence, if I could just read it for you, my Lord. The learned doctor, my Lord, says that in view of the medical report provided by Mulago National Referral Hospital, a follow-up medical evaluation was conducted at Luzira Women's Prison. Highlighting, my learned friend then said that there was no difference between the Mulago report, which is the Mulago report, just on the issue of breast masses. At page 2, it says breast examination revealed, quote, cystic mass in the left breast upper outer quadrant, close quote. So in February, she was found with a cystic mass in her left breast upper outer quadrant. That is R, which my Lord is singular. Dr. Chisambu, on his part, says, On examination, she was found with, quote, multiple fibrotic masses in the right upper quadrant of the left breast. The one problem had started multiplying. And he concludes, my Lord, by saying that his ability to assess and monitor, quote, the progress of multiple breast masses is beyond the capacity of the prison's health services. My learned friend is saying that if you are sick and the hospital has found that it can't treat you, it should keep releasing new reports. The fact that the doctor has said you have PTSD, hypertension, vertigo, and multiple breast masses. The fact that each time he must say, he must get in circumstances. Is not only not supported by authority, but it is actually a fundamental affront to the principles guiding bail and the presumption of innocence that were established in the Foundation for Human Rights Peace. Condition of an applicant must not keep worsening. You must not come and argue that you are not yet bad enough, because then pre-trial detention becomes a punishment. It becomes a sentence. My learned friend talked about the speed of the trial as a record trial. My Lord, there is nothing speedy about 15 months. My Lord, regarding her health condition, the applicant has herself deponed in her affidavit that she's unable to stand properly on account of vertigo. My Lord, my learned friend then spoke on the form of LC letters, and particularly on to be a surety, and on the affidavit in rejoinder, for which he said Mr. Kamuntu was being spoken for. Highlight it. This is paragraph 2E. The affidavit in rejoinder sworn by Augustine Obilil Idot, the lawyer for Mrs. Kantanga. He says, and I quote, regarding Mr. Geoffrey Kamuntu, I note that the allegations against him were previously raised in earlier bail applications and were found to have no merit by the Honorable Court. In fact, the court ruled he was a substantial surety for the applicant. A copy of Mr. Kamuntu's previous affidavit and the ruling affirming his credibility as surety are attached and marked C at it. So the rebuttals of the exact same things are contained again in Annexure C, which is an affidavit of Mr. Kamuntu. Go through that affidavit in any detail, the allegation. What is important, my Lord, is paragraph 11, that he has never been summoned for that alleged obstruction. But my Lord, even without a reply, the presumption of a court of law is the presumption of innocence. The prosecution should have said he has never been convicted. My Lord, briefly, what is important for the surety is that he must be of sufficient authority to ensure attendance of the accused person at trial. But Mr. Kamuntu's, the issues of Mr. Kamuntu are really that he was even the next of kin when the applicant was in hospital. And that is a relative and a cousin of the accused person. To go to the issue of the LC letters. My Lord, this court is not reviewing the suitability of the LCs. It is reviewing the suitability of the sureties. I'll start with Dr. John Patrick Kawai. And I think the objection to his LC letter if I understood it, was it is similar, word for word, to the to a previous letter raised. Area since the 1980s owns 200 acres of land. Was the area member of parliament, represented the area in the Constituent Assembly. He is widely regarded in the community. He is a senior citizen. He is her uncle. The objection to this letter is that it says exactly the same thing as the one before. My Lord, the court can take judicial notice of the fact that John Patrick Kawai was indeed a Constituent Assembly delegate. But he was indeed a member of parliament. Just like we know that Kantanga was also. That he owns 200 acres of land, that he manages coffee, bananas, mangoes, passion fruits. The applicant, my Lord, is saying that a paternal uncle, his age shows uncle, a responsible member. The court observed him, while his face looks 78, his body looks 40. As opposed to who were younger, because of disease, his brain, age, or of the fact that his LC used a precedent to draft the LC letter. My Lord, our LCs are ordinary people. Their letters will contain errors, their letters will contain certain mistakes, but the point is, they confirm he is their resident and a leader and an elder. And his substantial surety. I think the argument was that the person signed as General Secretary LC1, stamped as LC1 chairperson, and again a previous letter was written. Again, my Lord, we are not judging the LC system. It is, the police always had the capacity to go and check with LCs and see if they are genuine LCs. Even for the ones who are there, for the letters there. But my Lord, even that beside the point. Again, that Mr. Kamuntu, a next of kin, a businessman, a property owner in an area, should be judged on his own basis as a surety. Again, the objection to General Burundi seems to be that his LC wrote to the Chief Magistrate High Court. Again, which has not been contradicted, shows, apart from being the applicant's relative, he's a retired 3-star general of the UPDF, 2-star, he's a retired 2-star general of the UPDF, a retired diplomat, having represented Uganda in diplomatic service, a cousin of the applicant, and her immediate next-door neighbor in Tratu Road in Buya. That's a substantial surety by any measure. And the measure of his substantiality cannot be the civics knowledge of the LC1 chairman, who doesn't know that he's a Chief Magistrate of the High Court, as we submit and in summary. Quiet. My learned friend makes the final point. My lord, bail applications are simply supposed to be whether the accused's attendance at her trial can be confirmed. It is not to be denied, my lord, on the basis of every technical and flimsy ground. Bail ensures, my lord, that an innocent person is not punished before conviction. What is being sought, my lord, is punishment without verdict, is suffering without judgment, and is a prison sentence imposed. But this is finally, and I'll say this and hand over to my learned friend, Mr. Kantanga. And my lord, the purpose of the decision in Foundation for Human Rights Initiative, the cardinal principles, the presumption of innocence, the right to a fair trial, and the fundamental dignity and worth of the individual. My lord, we have detailed all of these in our submissions. And in their own summary of evidence, the prosecution says that from the events which led to bringing us here, the applicant was grievously injured in the quiet confines of her bedroom, and her health is a result of the injuries sustained on the 2nd of November. My lord, the applicant poses no risk to the society, no risk to the community, and there is no reason why, for the remaining part of her trial, she cannot be allowed to conduct her defense as she is treated and in the sanctity and privacy of her own space. My lord, the applicant, as we have said, is a mother of an infant of 11 years of age. My lord, I'll now, that did not come up, but my lord, it did come up in their submissions, but my lord, it's in our, I'm just highlighting that it's in our submissions, and my lord, allow me at this point to allow my learned friend, Mr. Kantanga, to wind up and to give greetings from myself to somebody.